Hello and welcome to the TTB Regulatory Update webinar, Labeling and Standards of Fill, hosted by NABCA. Over the past few months, TTB has revised several of its regulations about these topics, which two of their experts will cover today. Please note, this presentation is to help create an understanding to comply with the laws and regulations of the TTB. Before I introduce the presenters, I wanted to address a few housekeeping notes. Let me introduce myself. I am Maggie Barshimi in the Communications Department at NABCA. This webinar will be about an hour with an opportunity for Q&A at the end. Please type your questions in the chat box for the presenters to address. If your question is not able to be answered today, there will be follow-up after the webinar. I will also include an email address and web form links in the chat box for you to copy if needed. You can find the slides for this presentation under the Handouts tab in the GoToWebinar platform. This webinar is being recorded and will be available on the NABCA website within 7 to 10 business days. It will be under the Policy and Research section of the website. Our presenters today are Chris Tiemann, Distilled Spirits Program Manager in the Regulations and Ruling Division at the TTB, and Kurt Eilers, Beer Program Manager at TTB. Chris, the platform is now yours.
Thank you, Maggie. I'm going to go to the presentation now. So thanks for having us, Maggie, and thank you all for joining us today. We're happy to be here to give you guys an update of some of the things that TTB's been working on in the past few months. Just to start off with a little disclaimer, this obviously is not creating any new policy or regulations. This is just to give you an idea of information about the regulations. If there is any conflict between what we say today or what's in the regulations, of course, the regulations control. Sample documents are for illustrative purposes only as well. So today we're going to go over some rulemaking updates. First, we're going to go over labeling modernization project that's been going on for a number of years. We'll talk about some other label rulemakings and the standards of fill rulemakings. And as Maggie said, please provide your comments in the chat. We'll be happy to take some questions at the end. So I'm going to start off talking about labeling modernization for distilled spirits. I'm going to pass it over then to Kurt, who will talk about labeling modernization for malt beverages. And then he'll pass it back to me for some other updates. So starting with our labeling modernization project. This project we've been working on since about 2012, and in 2018, TTB published a proposal to modernize the labeling and advertising regulations for wine, distilled spirits, and malt beverages. The purposes of this were to reorganize the regulations, simplify and clarify regulatory standards, incorporate the guidance documents in current policy so that rather than having to look in many different places for how to create a proper label, it should all be incorporated into the regulations as much as possible, and to reduce the regulatory burden where possible. Many of the regulations for labeling date back to the end of Prohibition, and we realized that in order for industry members to be able to submit compliant labels, they need to be able to read and understand the regulations. So we took the steps of really looking at parts 4, 5, and 7 kind of from scratch, thinking about what requirements are necessary, which ones should be updated and changed, technological changes, things like that, and incorporated them into a revised document. So after that notice of proposed rulemaking was published, we received about 1,200 comments from a variety of industry members and took the time to review those. And on April 2nd of 2020, we published what we call the Phase 1 Final Rule. This rule finalized some of the proposals that could be implemented quickly, providing greater flexibility, as well as providing information for industry members about things that we've decided weren't popular and that we weren't going to continue with in the future phases. So the Phase 1 Final Rule covered all 3 commodities: wine, distilled spirits, and malt beverages. And here are a few things that were included for spirits. By the way, we're going to focus mostly today on the distilled spirits and malt beverage areas, largely because those are the rulemakings that have taken place recently. We are continuing the work on a phase 3 final rule, which will finalize the wine regulations as well as advertising regulations. So for spirits, one of the first things we did was the elimination of the concept of the brand label. Rather than mandatory information having to appear on the front of the bottle where consumers see it on the shelf, mandatory information now can appear anywhere on the label, as long as the brand name, class or type designation, and alcohol content appear together in a single field of vision. So this is similar to how wine labels have been for quite some time, where you might have a label on the front with a design and the back label acting as sort of the brand label with all of the mandatory information there. Another thing we finalized was an increased alcohol content tolerance. TTB increased the alcohol content tolerance for distilled spirits to plus or minus 0.3%. We had heard from industry members that with the increase in craft products and single barrel products, cask strength, it really was hard to meet such tight tolerances. And the United States had some of the tightest tolerances in the world for distilled spirits alcohol content tolerances. So we agreed with the industry and decided to expand that tolerance to make it easier to comply with. We had some changes to our age statement requirements for distilled spirits. Previously, many kinds of distilled spirits weren't allowed to have age statements or even terms like aged or barrel aged because they were considered to be age-related prohibited statements. Now age statements may appear on any distilled spirits except for vodka, because vodka can't be aged. And age statements may account for the time spent in multiple barrels, which may optionally be separately stated on the label. We made some updates to the standards of identity for distilled spirits. Vodka now no longer needs to be without distinctive character, aroma, taste, or color. This was again in response to consumer taste changes. If you talk to experts or consumers, you'll often hear that this vodka tastes a little bit different than this one, and we agreed. So we now changed the standard to be based on the distillation proof without regard to whether there's any distinctive character. We also incorporated some rulings which allowed for trace amounts of citric acid and sugar, just right into the regulations. We changed the designation of straight for whiskey so that it's an optional designation. In the past, if something met the category for straight, we required it to be on the label. Now, if someone chooses to use it, they can, but if they choose not to, they don't have to. So for example, a product that could be Kentucky straight bourbon whiskey, if for some reason the industry ever wanted to, they could just call it Kentucky bourbon whiskey, or of course just bourbon whiskey if they chose to, again, adding some more flexibility. We created a new class called agave spirits. Agave spirits includes tequila and mezcal, which of course must come from Mexico, but also domestic agave spirits or agave spirits really made anywhere. So that industry members who are making a product that would otherwise be kind of a tequila product, but isn't made in Mexico or for whatever other reason isn't a tequila, they have a category where they can label it and has standards behind it and won't require a formula in most cases. So on February 9th, 2022, we published the phase 2 final rule. So this final rule closed out the rulemaking project for labeling modernization for distilled spirits and malt beverages. Again, we were hoping to improve the clarity and usability of the regulations. One thing that I really think is useful with regard to the usability is we've made it so that the organization of the parts 4, 5, and 7 as proposed, 5 and 7 finalized now, 4 will be coming, so that they are all in the same order. So for example, if you know that in section 5.22 is where you find the information about a COLA for distilled spirits, you would know that if you're looking for the same thing for malt beverages, you go to 7.22, or for wine, 4.22. As we see more and more industry members starting to operate in more than one commodity, we hope this will make it easier so that industry members who are familiar with one part can find things in other parts. We're also, again, liberalizing certain requirements and assisting industry members in submitting compliant labeling and formula applications. So again, in this phase 2 final rule, here are some of the things that we did. We finalized a number of definitions such as container, distinctive or fanciful name, American proof, which is kind of an interesting one. You may know that the United States is one of the only countries that measures proof at 60 degrees Fahrenheit. Most of the rest of the world measures proof at 20 degrees Celsius. So that actually creates slight distinctions in the readings. So we wanted to make it clear that if you, especially for imports, but in general, labels should be done in the American proof. We provide clarity on what constitutes a label and what constitutes advertising material on a bottle. This is just to make it clear that if you have something like a hang tag on your bottle, that's considered advertising material and not the label. Similarly, a street cap or something isn't considered labeling information. We also provided specificity on name and address terms, specifically that blended by, made by, prepared by, manufactured by, and produced by are processing operations. So if you see something that says distilled by, that's a distillation statement. Bottled by can mean bottling in general, but these particular terms refer to processing operations. Did a few more things on standards of identity. One thing we did was we reorganized the standards of identity so that each class appears in its own section, hopefully making it easier to read and find things rather than having one section for all of the standards of identity with different paragraphs and subparagraphs. We clarified that a product may meet more than one standard of identity, but must only list one on the label. An example of something like that might be if you start with a vodka and add orange flavoring and sugar, that might be an orange flavored vodka, or it might be an orange liqueur. The industry member obviously can choose which one they want, but they must only list one on the label. You can't say on the same label that it's an orange flavored vodka and an orange liqueur. Either one would be fine. We also created a class called Distilled Spirit Specialty Products. We've had something called Distilled Spirit Specialties in our formulas online and our label applications for quite some time, but there was never actually a category in the regulations. This is still kind of a catch-all class for things that don't meet the other classes, but now there should be an easier way to understand what it means. And finally, we eliminated the concept of recognized cocktails. So you can still use cocktail names as the distinctive or fanciful name on the label with a reduced statement of composition, but rather than having a specific list or having to prove it using a bartender's guide or recipe, you can just specify that your product is a cocktail and label it in that way. To help everyone in going from our old to new regulations, we are publishing some navigation tables. In the regulatory document, we have what's called a derivation table, so that if you see where the new section is, you can look and see where it came from in the old sections to help you find things. We are also planning to put out a public guidance document that would have it the other way. So if you know where the old section is, it'll take you to the new section of regulations. And there is a link in the website, in the presentation right there to pull up these navigation charts. So now I'm going to turn it over to Kurt, who's going to talk about the labeling modernization project with regard to malt beverages. One moment while I switch the presenter.
All right, good afternoon, everybody. I'm going to talk a little bit about labeling modernization as it applies to malt beverages, and also a few changes that apply to both commodities, distilled spirits and malt beverages. Okay, so I'm hoping you all can, let's see, let me start my slideshow real quick. Okay, and we're talking about labeling modernization for malt beverages and cross-cutting. So as Chris was saying, label modernization started in 2012 and it's being finalized in different phases. So first I'm going to talk about phase 1, and I'm going to talk about 6 changes total. 4 of them are So as Chris was saying, label modernization has been implemented in phases. So I'm going to talk about phase 1 and then phase 2 of the label modernization rulemaking. So phase 1 has 6 changes. 4 are specific to malt beverages, and then 2 are cross-cutting, meaning they also apply to distilled spirits. So the first one, which is malt beverage specific, is our shorthand for it was alcohol by weight. And this allows bottlers to put the alcohol by weight statement on a malt beverage label in addition to an alcohol by volume statement. And we did this because there are a few states that require alcohol by weight to be on malt beverage labels. And we wanted to allow brewers to use one label across multiple states, whether they required alcohol by weight or not. This proposal also allows labels to include other statements such as fluid ounces of alcohol or proof, but always accompanied by a statement of alcohol by volume. The next change for malt beverages was regarding use of the terms draft or draft, depending on how you spell it. Previously, these terms were conditioned in the regulations. Either the product had to be unpasteurized or it had to be dispensed through a tap or a spigot if the container was 1 gallon or more. TTB determined that consumers would not be misled by the use of the term on unpasteurized products or products that did not have a tap. We sought comments on this issue and we didn't receive comments that consumers attached a specific meaning to these terms. And therefore, they are now considered just marketing puffery, and they no longer appear in the regulations. So any malt beverage label could be characterized as a draft product. Okay, the next issue involved strength claims, and I want to give a little background on this. Up until 1995, statements of alcohol content were not allowed on malt beverage labels at all. This prohibition was struck down by the Supreme Court. But another restriction on strength claims, which kind of called out the strength of a malt beverage, that prohibition lived on until this rulemaking project. So some examples of prohibited terms included strong, full strength, or pre-war strength.
Hey, Kurt. My apologies for interrupting, but the slides are not advancing. And what I'm looking at is the start of your presentation. So I just wanted to bring that to your attention. If you can, maybe adjust your view. I think I've heard you very, very well.
Okay.
But it's just the presentation of the slides. I'm just looking at where you start. Nothing has advanced.
Okay, thank you. That's really strange because I'm seeing the slides advance.
There we go. Now I'm seeing it. Now I'm seeing it. Yes, before it was just odd. But yes,
Okay.
now you're good to go. Thank you.
Okay. Thanks, Maggie. I appreciate that. So
Sure.
Here's the slide on alcohol by weight, which I covered first. And then this is the slide on the use of draft or draft. So if you are watching this at home, you can just pause the presentation for this material. And then I'm going to pick up where I left off talking about strength claims. So TTB proposed to ease the restriction on strength claims such that you couldn't suggest that the product should be consumed on the basis of its strength. But we received comments saying that would be a very hard standard to implement, and we ended up agreeing with that. And so the final regulations completely removes the prohibition on strength claims. So that is a type of claim that is now permissible on malt beverage labels that wasn't before. But I just want to note that there are some claims related to alcohol content that are still subject to conditions in the regulations in Part 7. And those include low alcohol, reduced alcohol. Those can only be used for products with less than 2.5% alcohol by volume. The term non-alcoholic can only be used if the product contains less than 0.5% alcohol by volume, and it must be accompanied by a short disclaimer statement stating what the term means. And then alcohol-free can only be used on products that contain no alcohol at all. Okay, the next issue, this is just a clarifying change, something that was added to the regulations for informational purposes. There are certain malt beverages that do not, there are certain brewery products that do not meet the definition of malt beverage under the FAA Act. They're still subject to some labeling requirements under the Internal Revenue Code, but not the FAA Act rules like Part 7 regulations and applying for and receiving colas from TTB. So those products are sake and similar products that fall within the definition of wine under the FAA Act. That's usually either primarily or exclusively rice fermented alcohol beverage. And then beers that are not made with both malted barley and hops. Sake may be required to be labeled under the FDA rules, If it's less than 7% alcohol by volume, if it's more than 7%, it falls under the labeling rules of Part 4 for wine under the FAA Act. And then beer that is not made with both malted barley and hops has those minor IRC requirements that I mentioned, but also has to follow FDA labeling rules. So things like ingredient labeling, nutrition facts, allergens, etc. Okay, so now we're in phase 1 cross-cutting, and there are 2 provisions here that apply to both malt beverages and distilled spirits. First, we added a definition of certificate of label approval. There wasn't one previously in the regulations, and that definition authorizes labels that are identical to the ones appearing on the face of the cola or with changes authorized by TTB on the certificate or otherwise. So those changes, we call them allowable revisions. They're all listed out on the cola form, and those are things that you can change without having to submit a new cola for TTB approval. Some examples of allowable revisions include adding a serving facts statement, deleting a reference to organic certification, changing bottling dates, or changing the net contents. Those are also, all the allowable revisions are also listed on TTB's website. And then the other cross-cutting provision from phase 1 regarded personalized labels. This is current policy, but we receive a lot of questions on how to do this. So we added the procedure to the regulations for the sake of clearly communicating TTB policy. So personalized labels have a cola, but certain information is allowed to change. It could be a personal message, a picture, other artwork. It could be for specific events or for specific customers. And the way to get a personalized label is to submit a template label for a cola. And that template has to be otherwise compliant with all labeling rules. The application should describe the specific information that may change from label to label. And then if all of that is compliant, you will receive a cola approval from TTB that has a qualification allowing for the personalized information to change. Okay, now we're moving on to phase 2. That was just issued this year in February. And that, as Chris mentioned, did reorganize the regulations in Part 5 and Part 7. So all the citations to Part 7 and Part 5 in this presentation are the updated, most recent reorganized regulations. And under phase 2, there are 5 malt beverage specific provisions that I want to cover. And then starting at number 6 in a few slides, I'll cover some cross-cutting provisions as well. So first of all, for malt beverages, phase 2 removed the distinction between bottling malt beverages into containers of less than 1 gallon and packing them into containers of 1 gallon or more. This was kind of a distinction without a difference, and it was just sort of confusing to tell people they had to call it one thing or another based on the size of the container. So now the act of filling malt beverage into containers is known as bottling generally. But if you have existing labels that say packed by or similar language, those are still in compliance because it's not misleading to say that. And the next one, it's a little complicated, but this was an exception for labeling for kegs in order to make it easier to apply a label without firmly affixing it, because brewers have told us it's very difficult when reusing kegs to have to scrape off the keg collar or other labeling every time. So I advise anyone who's interested in using this exception to go to the regulation at 7.51. But very briefly, if someone is using a keg collar or a tap cover to bear mandatory information that's not appearing anywhere else on the container, then there are a few options on how to affix that label to the container. So first of all, you can firmly affix it just like any other label. Second, you can not firmly affix it. So you could just have like a cardstock keg collar, put it on the keg. As long as the name of the bottler or the importer is permanently or semi-permanently stated on the keg. And that could be through a stamping, through a sticker, through inkjet printing, etc. And then finally, the third option is to have a keg collar or top cover that's not firmly fixed, but if someone tries to remove it, it would be rendered non-reusable. So that could be, maybe like an adhesive that sticks to itself, but not the keg. And if you try to take it off, it can't be reused. Okay, and the next provisions, the first one is just clarifying, and it states that descriptive terms that describe a malt beverage, like before the class and type termination, such as color, amber or red, or descriptive such as dry, those are permitted now. They always were, but it wasn't completely clear in the regulations. Next, we eliminated a requirement that certain mandatory information appear on a brand label. This is similar to the brand label changes that Chris mentioned for distilled spirits, except there's no single field of vision requirement. The mandatory information can appear anywhere on any label on the container. And that mandatory information includes things like the brand name, the class designation, the net contents, and the name and address of the bottler. Next, we removed a prohibition on terms like bonded or bottled in bond. It's still prohibited to imply something like government supervision or certification that did not occur. But for example, if you're a brewer and you have a bonded warehouse and you want to say, we aged this beer in barrels in our bonded warehouse, that's not misleading, and therefore it's not prohibited under the regulations. Okay, and now there are a few cross-cutting phase 2 issues. So these also apply to distilled spirits. We removed a prohibition on the use of country flags or any symbol related to the U.S. Armed Forces. These symbols are only prohibited if they create a misleading impression, such as endorsement or affiliation. And additionally, the U.S. flag can be used to signify that a product was made in America. Next, we removed a prohibition on labeling features that resemble a stamp of the U.S. government or of any state or foreign government. Again, something like this couldn't create a misleading impression or an implication that there was some approval that was not actually given. But overall, something that is somewhat resembles an official certification is not prohibited. And now continuing with the cross-cutting changes, we clarified that money-back guarantees on labels are permitted, and other types of guarantees are also permitted as long as they're not misleading. We clarified that endorsements of products on labels by living persons or existing public or private organizations are permitted. And we clarified our policy that formulas or samples may be requested at any time. May be requested at any time during the color review process. So if a labeling specialist thinks that they need more information to approve a label, then they may ask for either a formula or a sample of the product. And finally, phase 2, explain TTB's policies with regard to relabeling malt beverages and distilled spirits. So some of this is current policy, but some of it is also liberalizing, just to make things a little easier while still protecting the integrity of labels and the revenue. So products can be relabeled before removal from bond, or in the case of importers, before removal from customs custody, without seeking TTB approval first. Similarly, relabeling after removal from bond is not a problem, does not need TTB approval, as long as it's being done by the brewer, the distiller, or the importer in the case of imported products. And then relabeling by other brewers or permittees may be done with written authorization from TTB. So this needs approval from TTB, and it can only be done for very limited purposes, to replace damaged labels or to bring labels into compliance with Part 7 or with state law. So for example, if someone along the supply chain realizes that you have a cola for a certain label, but it's been changed along the way and it's no longer in compliance with Part 7, there's a a mechanism now to seek approval to have that product relabeled to come into compliance. And then finally, labels may identify the wholesaler, retailer, or consumer of a malt beverage, and this information can be added to containers without TTB approval and without obtaining a new COLA. So this is essentially a new allowable revision in the regulations. But because TTB won't see the new container after this information is added, the added labeling must not otherwise violate the rules in Part 7 or Part 5. It can't reference the characteristics of the product, and it can't obscure any other label on the container that the COLA would indicate should be there. Okay, that's it. And I'm going to pass the screen back to Chris to talk about some other rulemaking initiatives.
Thanks, Kurt. I think you need to make me the presenter.
Oh, there we go. Okay, I just had to confirm it. So you should be presenting now.
Great, thank you. Let me know if anyone can't see my presentation, but hopefully it's moving through. And also thank you all for submitting your questions. We're going to get to those at the end, but keep those coming. Those are great. So now I'm going to talk about a few other rulemaking initiatives that TTB has going on. Starting with some of the labeling rulemakings. One of the things that's pretty exciting, since June of 2021, TTB has finalized 15 American viticultural areas for wine. Those are grape growing and winemaking regions that are specifically designated by regulation. We had a proposal regarding labeling wines containing added distilled spirits. Comments are due on that rulemaking August 12th, so feel free to go on regulations.gov and submit comments to that. That regards prohibition on wines, even the ones that, such as fortified wines that are made with distilled spirits, from listing distilled spirits on the label. So we've received some inquiries where industry members want that flexibility to be able to say, you know, with added brandy or something like that. So feel free to comment on that rulemaking. We're looking forward to hearing what industry members have to say there. We proposed an addition of Singani to the standards of identity for distilled spirits. Singani is a brandy from Bolivia, and after negotiations between the United States and the government of Bolivia, we agreed to propose adding Singani to our regulations in exchange for Bolivia adding bourbon whiskey and Tennessee whiskey to their regulations as distinctive products of the United States, protecting the geographic source of those products. That comment period is closed, so we are reviewing the comments and will publish a final rule if appropriate. Also, last week, we proposed another standard of identity. It's the addition of the American single malt whiskey standard of identity to the distilled spirits regulations. This would be a distinctive product of the United States with some specific requirements that would put it in line with some of the other famous whiskeys around the world. Particularly, it would be from 100% malted barley, aged in barrels of any kind of oak barrels, new charred or used barrels. So that comment period will be open for 60 days. And again, we're very eager to get industry's comments on that and members of the public as well. There's not a link in here, but just go to regulations.gov to find that one. Some of our other rulemaking initiatives that we have going on. As I mentioned earlier, we worked on trying to simplify and modernize our labeling regulations. But we're actually, excuse me, I'm blowing my words, simplify and modernize. We're actually trying to do this in a number of other areas. So we have a tax simplification project that's going on, which would reduce the information through reports and returns that is required by industry members, really focusing on what information do we need. We also have a permit modernization project that's going to work on updating our permit requirements for all three, actually more than three, beverage and non-beverage and tobacco permit information. There's a brewer's notice of proposed rulemaking. The comment period is open right now. That would work on modernizing that. Comments are due there August 8th. Finally, there's a change to the Craft Beverage Modernization Act. That's the act that, among other things, produced significantly reduced rates for beer, wine, and distilled spirits. Also included some other kinds of provisions about transfers and bond and things like that. It had been a temporary provision for a number of years and was made permanent. And so a couple of the rulemaking initiatives we have there is putting the regulations in that would actually incorporate all of those provisions. Because it was a temporary rule, we didn't put them in the regulations at any time and then have to take them back out. But now they're permanent. We're working on inserting those. Additional, there was a substantive change to the import provisions. Previously, importers would be able to take the reduced rates upon entry of the products into the United States when they pay the tax to customs. There was a change in the law that Congress made so that now TTB will be the ones that provide refunds for the taxes to accommodate the reduced rates. So the importers would pay the full rates of tax upon entry to Customs and Border Protection, and then would file claims on a quarterly basis with TTB. So that takes place on January 1st, 2023. We're already starting significant work on our systems that will accommodate that. Foreign producers will need to register themselves starting this fall. So be on the lookout for guidance on how foreign producers can register themselves and agents, and then the claims process will start in 2023. Now I'm going to just touch on some standards of fill rulemakings that have been going on. On December 29th, 2020, TTB published a final rule that provided for 7 new standards of fill for wine and distilled spirits. Those are listed on the screen. One of the significant ones there was the 700 milliliter size for distilled spirits, which is the size used in a number of other countries. So this hopefully will help with exports and imports of distilled spirits and wine. Then on May 25th of this year, we published a notice that proposed to add 10 additional standards of fill for wine. Those are a result of negotiations with the government of Japan. And as an alternative, eliminating all but a minimum standard for wine containers and all but a minimum and maximum for distilled spirits containers. The comment period closed on that by July 25th. So we will now be reviewing those comments to see what the appropriate way forward is. I will say that over the last year or so, we've received a number of different inquiries related to supply chain issues and difficulties meeting specific sizes for cans and bottles. So we're really interested to see what the public and states especially have to say about these additional standards of fill. So in preparation for this presentation, we actually requested people to submit some questions in advance, and so I picked a couple that came in to go ahead and answer now. One of the questions that came in is there a consideration for a resealable package requirement for certain sizes of spirits containers? For example, 37% ABV mixed cocktails are presently in the marketplace in 750 milliliter bottles. That would be a pretty strong cocktail. I think most of the cocktails on the market are lower than that, but that's the questioner's comment. So it is a little complicated about the resealability requirements for distilled spirits. Basically, we have 2 lists of standards of fill for distilled spirits. The one on the left in paragraph 1 is the general one. And then in paragraph 2 is 4 sizes that apply to metal cans. And those are for metal containers that have the general shape of a can, a closure that is an integral part of the container, and that can't be resealed after opening. So if for a normal can, you would need to use one of those sizes on list 2. But for anything else, you can use the sizes in list 1, but there's no actual requirement in list 1 that it be resealable or not. So it's only for those specific, basically normal cans where the requirement is that it can't be reclosed. This was, I think, to reduce confusion when those sizes were added. And you'll note that 19.523 and a similar section 27.62 for imports talk about the fact that the closure must be constructed in a manner as to require breaking, but it doesn't say that it has to be able to be reclosed. So, you know, a tape seal, any kind of thing that requires breaking for tamper evidence is required, but but there's actually no requirement that the bottles of any kind be reclosable. Another question that came in, may my distilled spirits plant sell kegs of cocktails to restaurants for their on-premise use? The answer to that is no, unless they're very tiny kegs. The reason for that is Section 206 of the Federal Alcohol Administration Act requires that bulk spirits can only be sold in certain ways for certain uses. And that list is listed right there on the screen. Basically, primarily it's for transfers between distilled spirits plants, sales to the United States, sales for non-beverage purposes. But you can see that the law itself defines in bulk as containers having a capacity in excess of 1 wine gallon. So while by regulation we do have authority to prescribe lists of sizes, the maximum that we could do under the statute is 1 gallon. So there's really no way that distilled spirits plants could sell large cocktails, even if it's for on-premise use. Some contact information here, and you can take this down now or find it in the slides in the handout section. For labeling questions, you can reach our Alcohol Labeling and Formulation Division. The call center there is staffed by labeling specialists and formulation specialists who are very experienced and can answer your questions. There's a toll-free number, or you can use the contact us link to send an email that goes directly to the ALFD call center. They're open from 8 to 4:30 on Monday through Friday, except on federal holidays. If you have regulations or public guidance questions, you can contact the Regulations and Rulings Division. And I realize that says toll-free. It's not actually a toll-free number, but it's 202-453-2265. Or again, use the Regulations and Rulings Division contact form. That's probably actually the best way to reach the Regulations and Rulings Division, because the managers get those contacts and can assign them directly to the appropriate specialist to answer your questions. And you can always find www.ttb.gov, lots of resources there, and the contact us page for all the divisions at TTB. So now we'll move on to some audience questions. Let me stop sharing my screen. Okay, let me switch windows so I can see the questions that came in. Okay, we have a malt beverage question for Kurt. Can you go over the malt products that will not require a cola?
Sure, yeah. So I kind of covered this on one slide. You know, there are brewery products that do not meet the malt beverage definition. So something like a malt beverage that's not brewed with both malted barley and hops, that would be labeled under FDA requirements primarily and would not need a cola. There are some other issues as far as colas go. If a malt beverage is not being shipped in interstate commerce, you do not need a cola. And then if you're shipping into one or more states, you need to check whether the state law has rules that require labeling in conformance, like identically with the FAA Act. So I'd recommend looking at 27 CFR 721 for all those rules. But generally, if you're making a malt beverage and shipping it in interstate commerce, there's a very good chance you need a cola.
Thanks. And also another one for you. Can you put made with an organic raw material if the end product is not organic?
Sure, yes, you can. So TTB, we just implement the organic regulations in the same way that the USDA, the Agricultural Marketing Service, would interpret them. So I would go to their website. They have sections that talk about how you can make a claim, such as like made with organic barley, made with organic corn, things like that.
And a question came in for spirits. There used to be 2 levels for tolerance for the alcohol, one for spirits and one for liqueurs. Has that been merged into just the one plus or minus 0.3? Yes, that is the case. So because our tolerances used to be so tight, we knew that for liqueurs or other products that contained a lot of sugar or other solid materials, it was impossible to meet that tight tolerance. So we had a slightly larger one. But now that our tolerance is so much bigger, plus or minus 0.3, that covers what was previously incorporated for spirits and for liqueurs. So it's now all one tolerance level. Another malt beverage question, Kurt. Is sake only a wine product, cannot be a spirit?
Okay, that's a great question. I talked a little bit about sake in my slides. But I didn't mention that there are quite a few sake products that are made with distilled spirits. That's fairly popular in Japan, and we've received some questions lately about people wanting to do that in the U.S. So you can't have distilled spirits on a brewery premises or add them to a malt beverage product. So if somebody wants to make sake with distilled spirits added, that has to be done at a distilled spirits plant. So you would need a DSP permit. And it would also be taxed at the distilled spirits rate. So two important things to keep in mind there.
Another one for you, Kurt. For the updated allowable revisions, can you clarify whether separate colas are required or not for different malt beverage containers like kegs and bottles?
Okay. The short answer is it depends. If you have a label that's approved, you have a cola for it, there are certain allowable revisions that you can do without getting a new label approval, and those are on the form itself. It's probably the easiest place to find them. It allows you to do things such as change the net contents. So if you were going to a larger format but not making a lot of other changes, you could just change the net contents. There's also an allowable revision where you can change the colors, the shape, the proportionate size of the label. So really it depends on if it's going to be something somewhat recognizable and the product of allowable revisions versus just a wholly redesigned label. So if you're going from a square label to a keg collar, there's a good chance you'll need a new cola approval.
Thanks. And actually, now I'm seeing there was a similar question that came in about 12-ounce cans and 16-ounce cans. So the answer there would be the same. If it's looking the same or meets the allowable revisions, you can certainly use the same cola for both of those, 12-ounce or 16-ounce. But if it's significantly different or you're making changes that are not allowable revisions, those would need a different cola. And another thing about allowable revisions, this one came in about spirits, but it applies to all of our commodities. When we have bottle numbers in a limited release, can we reuse the same cola approval once the first one is approved, or do we need a different one for each bottle number? Bottle numbers are an allowable revision, so you can certainly reuse the same cola as allowable there. Someone asked, we are in the design process of our label. Where are these policies available so that our designer can follow these requirements? So for distilled spirits and malt beverages, well, really all the commodities, current regulations are what I think is the best place to look. Those are available at www.ecfr.gov. Parts 4 for wine, 5 for distilled spirits, and 7 for malt beverages. We will be updating the beverage alcohol manual to incorporate the regulatory changes, and so that will be taking place, but all of the new regulations are not yet published in the beverage alcohol manual, so the regulations are the place to look. And in the very near future, the government printing office will actually have the new copy of the printed CFR book, that's the Code of Federal Regulations book. Hasn't quite been updated yet. It seems to be going a little more slowly this year. I don't know if that's because of COVID or I'm not sure why. Usually they come out in June, but it should be any day. You can go to bookstore.gpo.gov to order those printed book copies. Kurt, another malt beverage question. What were the prohibitions that were removed from bottled in bond and bondage?
Okay, so yeah, I covered that in one of the slides. Previously, the regulations prohibited the use of those terms, anything related to something being bonded or bottled in bond. I guess what remains is that you can't use those terms in a way that would be misleading. So yeah, saying that like the government supervised the storage of the malt beverage would be misleading, but saying that we have a bonded warehouse where we age our beer in such and such barrels, that would be fine.
And then, is a beer formula approval required for a product made with malt and hops but not fermented? The product is 0% ABV.
That is a tricky one. So my first instinct is to say yes, you would need a formula. So TTB's formula requirements are in Part 25, specifically section 25.55. And it's fairly broad. It applies to, basically it applies to all brewery products, regardless of alcohol content. So it would either be, a product is either a beer if it's 0.5% or above, or it's called a cereal beverage if it is less than 0.5%. And the definition of cereal beverage says fermented or unfermented. So I would, if you are making a product like this, I would get in touch with ALFD, that's TTB's formulations department. But my guess, my first impression is you probably do need a formula for that type of product.
Thanks, and this is probably a good time also to make the point that the formula requirements apply to breweries whether or not there's a necessary label requirement. So for example, if you're producing a beer that's only going to be sold in one state, the beer regulations may require a formula for that product. Not all beers and malt beverages need formulas, but some do. And if they do, the formula would be required even if there's not a label requirement for that malt beverage. And I think we have one more question that came in. I think it's time for that last one. For vodka, with the limitations for citric acid and sugar, is that added directly or through a blender? So that's either way. You can add the sugar and citric acid directly to the vodka if you choose to, but you can also make those in a blender, which could be done for convenience purposes or tax purposes. So you can add those to the vodka. The limitations that are in the regulations apply whether it's added directly or through a blender. So make sure you don't go over the limitation even if it's in a blender. I think those are probably all the time we have for questions today. So now I'll turn it back over to Maggie.
All right. Thank you very much, Chris and Kurt, for your time and for sharing your valuable knowledge with us. We thank you for joining NABCA and TTB for this presentation. Also, please visit the nabca.org website for various resources, including white papers, previously recorded webinars. There are 2 others from TTB that is available on that website, one that covers alcohol beverage advertising and one that addresses unpacking 4 prohibited trade practice violations. And there are other materials there as well. It is our goal to give you the information and the tools that you need to perform your functions effectively. And please be on the lookout for a NABCA survey that will soon be sent to you. We'd be grateful to have your feedback. Thank you again. The presentation is concluded. We wish everyone a great day. Thank you again, Chris and Kurt. Bye.